afternoon, everyone. We are Nur Butenate, Julie de Klerk, and myself, Cristina Arcones, and we're going to present the Zobory case. First, we're going to begin by explaining some of the facts of the case. Then we're going to explain the legal issue. Third, we're going to do an analysis of the case. Then we're going to proceed by doing the ruling, and then we're going to end up with a little conclusion. Okay, so let's begin with some of the facts of the case. So around the 15th of December in 1986, the applicant was employed as chief accountant by Canon Australia. He withdrew the sum of 1 million out of an account held by the company, and then later on deposit this money into an account under his control. So as a result of a different series of transactions involving transfer to different bank accounts and deposits, there were substantial sums of interest that were earned during 1988 and 1989 in respect of the amount of 1 million taken from Canon. So the applicant also invested a small sum of his personal money with the stolen money. He also invested some of the money in the purchase of a house, which was later reposted upon its sale. Neither counsel suggested this investment had in itself any particular tax consequences. Later on, in August 1989, it was discovered what happened, and then instituted proceedings by summons in the Supreme Court of New South Wales against the applicant, claimed an order for payment of 1 million with the interest pursuant to Section 94 of the Supreme Court Act of 1970. The declaration of that money was held in the account into which the applicant had originally paid the sum of 1 million that was held by him on the trust for Canon, and then the relief including a declaration that any assets acquired by the use of the money were held on trust by the applicant for Canon. Later on, the Supreme Court alleged that the applicant had fraudulently misappropriated the sum of 1 million, and then stated that Canon contended the monies which were misappropriated and any assets purchased with them are held on trust by the applicant for Canon. Then on November 1989, orders were made by consent and without admissions by the Supreme Court of New South Wales, which required the applicant to pay, and then he was charged with certain assets of the applicant in favor of Canon to secure the payment of that money. He later on was also charged with an offense under 166 Act of the Crimes Act, and this section makes an officer who cheats or defrauds his own company liable for imprisonment for 10 years. So to that change, the applicant pleaded guilty, and he had submitted his tax return for the year 1988 before the crimes were uncovered. Later on, by the time he submitted the return of the year 1989, the truth was known, and even though he generated by the applicant was the property of Canon, the applicant lodged an objection on the same basis to the assessment which had issued to him in respect of the previous financial year. He was allowed to object out of time, but the objection failed. As a result, he was assessed liable to income tax in respect of the whole of the interest for both years.
So the applicant of the taxation appeals was prosecuted and sued in the Supreme Court for the recovery of the money and for the interest earned by its use. But in the meantime, investments had spanned 2 financial years, and the question that arose was whether the income represented by the interest, although fully disgorged to the rightful owner of the money, is nevertheless taxable as the income of the applicant himself.
Okay, so now I will be focusing on the analysis of the case. So McFarland versus Commissioners of Taxation 1936 was one of the main precedents applicable to this case. It basically established that a constructive trust is an effective remedy to divert liability to income tax of the beneficiary. So a constructive trust is a remedy that is imposed by a court that allows a party that has been wrongfully deprived of his rights due to an unjust enrichment of a breach of fiduciary duty. Accordingly, in this case, it asserted that the money taken from Cannon was held upon a constructive trust of which Cannon was the beneficiary. However, the interest earned was income of a trust estate and was not income derived by the applicant's money personally. It followed that the objection should have been upheld, such as so stated in Black versus Friedman Company and Company in 1910, where money has been stolen in his trust money in the hands of a thief, and he cannot divest that of its character. So this was criticized, by Millet L.J., who made it clear that whatever the position may be in which it may be in a case of simple theft, a person such as the applicant in this case, who was Cannon's chief accountant, is a fiduciary upon whom the obligation of a constructive trustee may fall. Now, onto the admixture of funds, which was one of the main issues of the case, since the applicant personally mixed his personal assets with the assets he stole from Cannon. Now, the commissioners for this case argument treated constructive trust as a mere remedy imposed by a court, rather than also a species of trust attaching to the property at the time of its taking, to the income at the time it was first earned. So the commissioners suggested that a charge might be imposed for the regain of the money instead of a constructive trust conferring a beneficial interest for Cannon. In Attorney General for Hong Kong versus Reed, 1994, it was suggested that debt equity can coexist with a constructive trust as long as they don't result in double recovery. So two remedies may be imposed as long as it doesn't result in a double recovery. However, the commissioners went against this idea. In that, Attorney General also asserted that the equitable ownership of the money invested by the applicant doesn't depend on a court declaring the existence of a constructive trust. In Scott's Law on Trust of 1967, it mentioned that where title of property is acquired by one person under such circumstances, that he's under a duty to surrender it, and a constructive trust immediately arises. And as a general rule, it was universally accepted that the beneficial interest on property is from the beginning in the person who has been wronged, and the constructive trust takes effect from the moment at which the contract has given rise to its imposition when it occurs. This was this was one of the focal points of Rawlik versus Rawlik, 1919. Now, Justice Burchett, which was the judge of this case, believed that the admixture of the applicant's personal funds did not matter unless it was inextricably mixed. So that means that you couldn't take apart what funds belong to who. So following that, the Australian Postal Corporation versus Lusac 1991 actually mentions that the admixture of trust money with money of a trustee are easily severable, so we can easily distinguish them, because financial investments represented by a deposit that have been increased by interest can easily be distinguished through arithmetic to identify which gains belong to the beneficiaries. Now, I will let Noor suggest talk about Justice Burchett's ruling of this case.
So for the conclusion, we will take a look to Judge Burchett's opinions. The commissioner's argument suggested that because a wrong beneficiary may have a charge over property acquired by the wrongful use of trust money, that there is no relevant constructive trust affecting any profit earned. But the beneficiary may choose the remedy of a charge as means of enforcing his right. The right itself does not grow out of the beneficiary's choice. He's able to choose the remedy because he already has the right. The establishment of a constructive trust required more than proof that the monies invested belonged in fact to Canon, proof of which does not require upon the applicant's own wrong. The applicant acknowledged the rights of Canon and has restored its property, including the interest earned on investments, which is presently in question. However, the annual basis upon the income of the taxpayer of the period doesn't require the true facts to be ignored because only revealed after the end of the year of income. The counsel for the commissioner cited the decision of the Supreme Court of U.S. in Healy versus Commissioner of Internal Revenue in 1953, where monies of which the taxpayer were subsequently found to be constructed trustees were nevertheless held to be taxable as their own on the basis that they had made a claim of right to the monies during the relevant year of income within the doctrine which obtains in the US. But the Supreme Court conceded that there were inequities of treating an amount as income which eventually turns out not to be an income. An examination of this decision shows how complex an adjustment was required to achieve its purpose, the claim of right doctrine, has not so far been adopted in Australia, and no such mitigating legislation had been enacted in order to make it palatable in the context of Australian taxation laws. If this doctrine is to be adopted by judicial decision, he don't think he it would be possible because it would be such a big step. So for these reasons, Justice Burchett hold the applicant's contention that he is not liable to the assessment which have been issued in respect of the income of the product of the sum of 1 million taken by him from Canon, and finally the appeals are allowed and the applicant is entitled to his costs. So this is all, and thank you so much for listening.